What is going on, IP family? I am your host, Dave, a 10-plus year intellectual property attorney dealing with everything from copyrights, trademarks, trade secrets, as well as patents. Now, instead of coming to you guys live today, I'm pre-recording this. We got to fly it back from Chicago when this is played. So it's going to be cool. I'm going to try to interact with the chat as I'm flying back and this is being played. But I still wanted to give you guys the current events for the week, the IP for the week, if you say, as opposed to kind of skipping a week. So, I mean, I thought to pre-record this. Like I said, this will come out Sunday, 7:30 p.m. Eastern Standard Time. Please hit that like button for your boy, as well as please hit that subscribe button to be a part of the IP community, man. I think that interview with Lonnie Johnson, the inventor of the Super Soaker, comes out here in a couple weeks. So, hey, that's going to be an explosive interview. So definitely you want to catch that one. And yeah, man, we got a full show for you guys today. And I think it's probably headlined by the Damon Dash interview on the Breakfast Club. I do want to really kind of play some snippets from that because he was talking a lot about intellectual property that I just disagree with. And I think not only is false, but it's kind of dangerous to kind of spew those things when, number one, you really don't know. And then number two, you still have a massive audience and people listen to you. So when you're kind of saying things about intellectual property that's not true, me as a practitioner, I kind of need to come correct those things, just especially so that the African-American community or culture doesn't think that, okay, I can kind of proceed in a way that he's doing it and I can be okay, because you will get sued and, you'll probably end up in a situation where you're kind of filing for bankruptcies left and right and kind of going around saying I have no assets in my name and kind of really saying that for the wrong reason. So we will talk about that. Again, it seems like another Chinese AI company is in the news. So we'll talk about that a little bit, and it seems like kind of some big studios, Disney, NBC Universal, as well as what was the other, Warner Brothers, teaming up to sue that Chinese AI company. So we'll talk about that. Bill Belichick, the trademark ruling from the United States Patent and Trademark Office has been that verdict has came in. So we'll take a look at what they said, and then we'll kind of take a look back at an old video for your boy and see whether or not my predictions as to these trademarks being issued was right or wrong. So that'll be interesting. What else do we have here? Rotor-Rooter. I know a lot of you guys know about Rotor-Rooter, the plumbing company. I think it's a franchise, if you will. That's the kind of the lawsuit breakdown of the week. So we'll get off into that. There's no buy it now for the week, just because I haven't done the videos yet. I haven't gone through and reviewed the videos, but I am pleased to say that next week, I think on Wednesday, a new season of Shark Tank is coming around. So we will be hitting that hard and strong. I'm excited about that. Excited about bringing those folks on to interview them as well. So be on the lookout for those updated interviews and kind of Shark Tank reaction videos. And I think that's pretty much it. I do want to kind of shout out some things. Hey, go check out the ebook, Got IP. It's pretty much from your ideal all the way to selling your ideal, monetizing it, I should say. It's kind of take you through those steps. That link is in the description. There was a couple people that kind of swooped them up, I think, this past week, which was pretty cool. And I actually got some heat coming, man. I got some heat coming on some physical products and digital products. I actually got a message from the trademark office yesterday saying that one of my trademarks is going to be issued. So that's cool. I have the books with the copyrights. I'm coming out with the patents on the products. So your boy is kind of, we for the start getting off into this, not just as a practitioner, but as an entrepreneur, businessman as well, kind of selling these products that are protected by way of various intellectual property. So go check out that. Then I got on a shirt as well, Peace, Love, Intellectual Property. Go purchase that shirt. That link is in the description as well. Now, that purchase shirt doesn't have my logo, which is the SE on it. It just has Peace, Love, and Intellectual Property. You will get stopped on these things. People ask you, hey, man, what do you know about intellectual property? What do you do? Do you have a business? So this is a way of serving as organic marketing for your business. So definitely go get those shirts. And I think that's pretty much it that I wanted to, I guess, kind of market or promote. We're going to start with the interview of the week, which is Jamie, man. And before I pull up and kind of play a snippet of that interview, and Jamie, just some of his background, and go check out the interview. He's in that kind of East Coast New York area, firefighter and a tattoo artist. He was able to, again, one of the first chapters in the ebook is talking about how do I come up with a product for my business. And the two ways I kind of give you, I'm giving you guys a little bit of a snippet of the book here. I talk about, hey, we all have worked for 10, 15, 20 years. You learn some things at work. You learn some deficiencies of the process. So that's a good starter to come up with a product or some type of a service for you to kind of use as a product for your business. Then the second thing is, hey man, we kind of do different things around the house that we just kind of hate doing, or we think that the product or whatever the case may be that we have kind of bought from the stores to use is inefficient, not ineffective as well. So that's another way to come up with an idea for your product to start your business. And what Jamie has done, I'm not sure if you can tell here, he has tattoos. He's a tattoo artist, and he's come up with essentially a numbing cream so that you apply it to your skin or the area that you're going to have a tattoo applied. You do that before, like an hour or so before your tattoo. And hey, I have a couple tattoos. My boys can, they can sting a little bit, let's just say. But the numbing cream really helps out in terms of kind of calming down that pain. So again, he, in his case, took something from his day job, so to speak, him being a tattoo artist, that he gets a lot of complaints of, or people don't like that part of the process, and he came up with a product to make that better. And the cool thing is, he's a tattoo artist and a firefighter, so he doesn't know like chemical formulas and things like that, but he worked with the right people to kind of get that job done, whether it's chemists, whether it's people who kind of deal in chemistry. I think he got a patent attorney who's a chemical engineer who reached out to me as well this past week and told me it was a good interview. So, man, he's working with the right people, even though he doesn't have necessarily the expertise to kind of get the job done, working with the right people. So don't be afraid, man. Even if you're going through this entrepreneurial journey, you're not going to know everything. You probably don't know most things, but as long as you have that vision, you have that work ethic and drive, and to be able to kind of continue to get up when you get knocked down, you can participate in this intellectual property or this entrepreneurial journey as well. And you can really do that while kind of juggling multiple things. Again, he's still a tattoo artist and a firefighter and a businessman. So he has three things going on. He has his business with Painless Picasso, which is a numbing cream. He's still a tattoo artist and he's a firefighter. So you can kind of juggle multiple things and have a lot of success. So with that being said, let's kind of pull up the interview from Jamie. Go check out the interview as I'm pulling it up here. I'm just play a snippet. Just play a snippet of it. I'll put it on here. He's out of Jersey, man. So I think Jersey or New York, one of them. And I know their life is different up there based on what he's explaining in the interview. I'm not sure how you can grow up in that environment and not be different. But nonetheless, let's see what he has to say. Let's go.
In a tough neighborhood, but if you grow up in New York City or like a metropolitan type area, you grow up fast, no matter what. That's just how the city I feel. When you grow up very fast. So, yeah, it's crazy. But going into that question, and somebody that, let's say they don't have that, like, again, I have a salary, I'm well at this point in my life, right? But I come into this point in my life with an experience of not having that. And that's the advantage of coming from where you come from. If you're listening to this and you come from, the trenches, what they say, right? You from the mud, whatever's happening, like, that is an advantage. Don't look at it as a crutch. Don't look at it, you have a gift.
And I actually like that snippet, man, because at the end of these interviews, I typically ask the business owner, hey, what advice would you give to aspiring entrepreneurs? And Jamie, again, grew up in New York metropolitan area. I mean, they ride in subways and trains by themselves in middle school to school. That's crazy. I have a 7-year-old daughter, and man, to think that she's in New York City like that, riding 10, 20, 30 minutes, whatever, from home to, taking a subway or train to school by herself or by himself, if it was a son, that's kind of crazy. But again, that's just kind of how it is in New York. And he was saying pretty much in that clip is, man, if you were coming from these, what they call the trenches or these urban areas where, you maybe don't have a lot of resources growing up, you have an advantage because you don't have anything, or you have very little, so to speak, as it relates to resources and financial prowess, or whatever the case may be. So you can kind of take that, use that when you're building a business, knowing that, hey man, I came from nothing. So anything is a kind of a plus or a bonus when I'm doing in business. And it's not like you have to kind of live this luxurious lifestyle before you actually start doing well in business. So, man, really kind of using your background, your environment, your experience, where you come from, everything that taught you, maybe even not having, and kind of build that business up as an entrepreneur, and understanding that a lot of people are not going to tell you this, man. It's almost like what they say, if you want whatever, put it in a book, and people not going to tell you this, but man, when you come from those tough environments and had to really overcome things left and right, I'm talking about I mean, you have to overcome some real stuff when you're growing up in those kind of urban environments that Jamie is talking about. You not only build callous, but you also have to grow up quickly, and that serves you well when we're talking about business. So again, go check out the interview with Jamie, man. Shouts out to him for doing it. He was on Buy It Now, so he was on Amazon's hit show Buy It Now, and I think he actually won $20,000, man. And he's coming up with some cool stuff. I know you see the numbing cream on the picture to the left that you put on the area that maybe having some pain or you don't want to have pain in when you're getting your tattoo. But he has spray. He's coming up with some patches to kind of help out, and all this is natural, organic stuff. He kind of talked about his inspiration for doing it is a lot of people don't want to put these chemical-based pain relief creams on or kind of products on their body because it kind of changes kind of your skin, makes it rougher, and just, again, it's chemical-based, so who knows what that's doing to the skin and the human body. So he has came up with a natural product with his Painless Picasso. I love the name, by the way. But not only that, he's expanding a product line. Like I said, he has sprays. He talked about coming out with some patches and really kind of doing some cool things. So shouts out to Jamie. Go check out that interview. And, hey, more importantly, go check out the product, man. That's a good product. So let's move on here. We are talking about your boy Bill Belichick. I think he did got a couple wins at North Carolina. So I think that first game was pretty tough, but kind of bounced back in a major way. But I do want to talk about his trademarks. So him, as well as his girlfriend, his younger girlfriend, Jordan Hudson, I think is her name, filed a number of trademarks. I think she filed a slew of them back in April, and then she filed another slew back in August, which is last month. It seems like a few of them from back in April, late March, the USPTO has rendered a verdict on it. So before we get to that video of a news broadcast talking about the verdict, I want to play my video from 3-4 weeks ago that talked about what I thought was going to happen. So let's see if your boy knows his stuff with regard to this trademark stuff. Make sure it's on the right speed here. Yep, it's cool. Let's go. Let's see what I'm talking about. Trademark. Let me pull up here really quickly. I was looking at this. Look at all these trademarks that she's filing. So they filed these marks in April of 2025. So my birthday month. You got No Days Off, Bill's Virgin. Do Your Job, Bill's Virgin. Ignore the Noise, Bill's Virgin. Dynasty, Bill's Virgin. And Chapel Bill's Virgin. That was back in April. Now, I'm not sure if she's going to get any of these for that matter. I think a lot of these already had been filed. Some of them been filed by the New England Patriots, Robert Kraft and the New England Patriots. And to be honest with you, as a trademark attorney, and I'm going to keep an eye out on these things, I don't think adding Bill's Virgin to the end is going to help out at all. That's kind of my thought. So I'll be interested to see how it plays out, but I don't think she's going to get many of these, if at all. Maybe Chapel Bill. But again, adding Bill's Virgin to a phrase or a name that's already trademarked is not going to help out. So let's go back here for a second. So I said they got No Days Off, Do Your Job, Ignore the Noise, Dynasty, and then Chapel Bill. I said maybe Chapel Bill, but these other ones, forget about it. Adding Bill's Virgin, like I said, the New England Patriots already filed, in a lot of cases have registered trademarks on pretty much all of these, maybe outside of Chapel Bill. So I said before the results came out, which I think this video was like 3 or 4 weeks ago, that I don't think your boy going to get the trademarks. So with that being said, let's kind of go to I think this just came out like this past week. Let's kind of tee up that and see what the news says about it. Seems like the news, some news anchors were talking about it and bring you the coverage. Let's see if your boy was right. What do you guys think? Let me know in the comments. Let's go.
You've likely seen that motto ever since North Carolina hired Bill Belichick in December, but who owns it?
Or some of the other phrases that we associate with Belichick, things like do your job, ignore the noise, or no days off. We turn now to WRL Sports investigative reporter Brian Murphy for some clarity on all this, Brian.
Well, guys, it turns out the process for trademarks isn't easy. Jordan Hudson, Bill Belichick's girlfriend and business partner, has filed for nearly 24 trademarks, most related to Belichick since late March. But the U.S. Patent and Trademark Office has rejected a few of those applications in recent days, including Ignore the Noise, Bill's Version, the Bellustrator, Bill's Version, Do Your Job, Bill's Version, and No Days Off, Bill's Version.
So, hey, your boy seemed like I know what I'm talking about. So the Bellustrator was not on that list that I previously showed, but Ignore the Noise, Do Your Job, and No Days Off all were rejected, which I correctly predicted by the United States Patent and Trademark Office. And a big reason for that is, number one, New England Patriots has already protected those slogans, phrases by way of a trademark and adding Bill's version onto it is not going to help out. And like I said, the Belichick wasn't on there, but it seems like New England Patriots has also kind of got that protected.
There's a reason those say Bill's version. That's because the New England Patriots fought for those trademarks when Belichick was their head coach. The Pats own those trademarks. Some they've owned since 2009. I spoke with a trademark lawyer today.
So there you go, man. Your boy look like he know what he's talking about as it relates to these trademarks. And I think this is really some learning lessons, because I just don't want to kind of bring you guys the IP current events. I also want to kind of give you guys some learning lessons from these. And the number one learning lesson is, man, just hire an attorney. I'm assuming that obviously Bill Belichick and his girlfriend has the money to go to an attorney. I'm not sure if they don't like what the attorney said, or they just try to do this themselves and kind of save the money or whatever the case may be. But an attorney, a trademark attorney, would have told you that you're not probably going to get these marks trademarked. That's number one. Number two, make sure you're protecting this stuff early as possible. I always look back when I see a name or a slogan or a word or whatever the case may be, and I think it's interesting. I'm like, man, that person should say it. In a lot of cases, if I see it on like social media, I'll type in the comments, hey, make sure you trademark that. Or I send them a DM or a PM, hey, make sure you trademark that. Because when you start to put the stuff out there in the ether, other people are kind of thinking about it differently from you. And this is exactly what New England Patriots did. All these terms are coming up to Illustrator, no days off. The unfortunate part of this is all of these slogans and terms were more or less invented or created by Bill Belichick. But Bill is just kind of saying them willy-nilly, and New England Patriots saying back like, man, those we can kind of protect these and kind of make it a thing off of them. And New England Patriots, they filed for the trademark protection on it. Then kind of years later, when Bill got with the new girl, and she's like, hey, man, we need to kind of protect this stuff because these stuff we can monetize off of it, selling merch, things of that sort. It's too late because New England Patriots already have the trademarks for them. So again, it's unfortunate because Bill Belichick really came up with all these terms. However, he does not get a chance to own them. So again, if there's another learning lesson in these things, before you kind of put something out in the ether, make sure you are thinking long and hard. Do I want to trademark this first? And to the extent that you do put it out and it sounds catchy, you probably definitely want to trademark it. And I guess last but not least, if somebody else trademarks or protect a term or slogan, you try to just put Bill's version or David's version or whatever your name's version of the mark, we know that that's not going to work. So you might as well not even waste the money, because even if they had to do this themselves and without an attorney, you still got to pay the USPTO $350 per class. So just say they file 10 marks in one class each, you still got to pay the trademark office $3,500. And I would imagine that they file each of these marks in 2 or 3 different classes. So they probably pay, upwards of $10,000+ on these marks, which I could have told you that was a waste of money. So hopefully you guys learned something from that. And I guess more importantly, man, your boy seems like he still got it. I know what I am talking about as it relates to these trademarks. Let's move on to the next topic, man. Chinese AI company. What's the name of the company? I'm going to pull them up here in a little bit. The name of the company is Minimax. And you know how I feel about the Chinese companies. You know how I feel about AI companies. So when you have a Chinese AI company, hey, whatever they said that they did, in my opinion, they most likely did that in terms of whatever infringement or wrongdoing. But again, I did a full version of this video, so go check out that video. But pretty much what's happening is these AI companies are making money. I think Minimax was, again, Chinese AI company. I think they had millions of subscribers, and their valuation is $4 billion. So these AI companies are making money. However, I think this is an important time more than ever to make sure you have intellectual property, but you are protecting it. So in this case, it seems like, and I have never used Minimax, but it seems like Minimax, they are an AI company that allows you to say, okay, hey, let me put Darth Vader on a beach with, I don't know, a particular set of clothing on. And it seems like Minimax will generate that image for you. And you're like, okay, yeah, I got my image. I'm going to do whatever I want to do with it. The problem is that Darth Vader is a protected term. Definitely is protected via copyright. I wouldn't be surprised if Darth Vader and Star Wars and Disney has that also protected via a trademark as well. So again, these terms that these AI companies are producing for their customers, for their consumers, such like Minimax, they're protected terms. And when you do that, you are, especially if you don't have authorization or approval or a license from the owner of that copyright or trademark or IP, you're committing IP infringement. In this case, it seems like Disney, NBC Universal, and Warner Brothers have ganged up against Minimax specifically, went after them for copyright infringement for allowing consumers to essentially kind of generate these protected terms without giving their authorization for Minimax and their AI platform to do that. So that's essentially, in a nutshell, what's going on here. Like I said, Minimax is a big company, man, $4 billion. It's not a small company by any stretch of the imagination. And yeah, man, it seems like the big three, that being Disney, NBC, Universal, and Warner Brothers, have sued them for copyright infringement. So like I said, in my opinion, this is the most important time to own intellectual property, because as AI kind of starts to continue to take over and everybody kind of get hooks onto it, the different AI platforms, you are going to have to still get protection from or authorization from these intellectual property owners to use their AI. In this case, the images, I think Anthropics, they agreed to pay $1.5 billion to authors for their copyright. So again, when somebody kind of develops a book, that's a copyright, and to the extent that they want to use that copyright for whatever reason, or they want to kind of regurgitate or regenerate that book essentially for a consumer, they have to get permission from the authors. Anthropics in that case did not do it. They took them to court, class action, I think it is. A group of authors band together and sued Anthropics, and Anthropics just recently agreed to pay the authors $1.5 billion. So again, in this case, it seems like Disney, Universal, NBC Universal, and Warner Brothers has ganged up for a similar situation, again, for copyright, albeit images, not a book, but images this time. And I think intellectual property is more important than ever to own, because even though these AI platforms and these tools are very useful and efficient, makes our life easier, they can't just be reproducing copyrighted or protected works willy-nilly without authorization. To the extent they are doing that and you find out about it, you can sue them for intellectual property infringement. So kind of keep that in mind as we're going through this thing, because like I said, man, I just think this IP is going to be more important than ever these days. So let's kind of move on. We got one more to get to before the Rotor-Rooter lawsuit of the week. And it's your boy Damon Dash, man. We're gonna pull up his interview. We're gonna go through a couple clips. Let me see, man. Let me pull up this thing. Where are we at? Where are we at? I do want to say, the reason I wanted to talk about this, because do I think Dame is broke? Personally, yes, I think he's broke, in my opinion. However, I do think he has maybe access or control to funds, and that by way of the family office that he kind of talks about in his Breakfast Club interview, which again, there's nothing wrong with that. A big part of what he has, a part of kind of was giving him that is intellectual property. But on the flip side, the part of, a big part of the reason why he's kind of getting all these judgments and having to file bankruptcy and things like that is because of intellectual property. So that's interesting that I think he has control and maybe kind of resources by way of his family office, because he have books, which he kind of brought some books on there, which is a copyright, because he has music, which is a copyright, because he has businesses and names and things of that sort, which are trademarks. He has movies, which are copyrights, TV shows, which are copyrights. So he has a lot of intellectual property that I think he kind of owns and monetizes off of, not maybe personally, but I think the family office does. And whether it's his girlfriend or his wife, and other people that kind of work with them, kids, whatever the case may be. But I do think, in addition to obviously the child support issue, I think a big part of what's holding them back as relates to people kind of suing them and getting judgments against him is because he's committed intellectual property infringement, copyright infringement, things of that sort. So I think he has, IP is helping him out, but IP is also hurting him. But he said some things in this interview that I just can't get with, number one. And then I think it's dangerous because it was so false and so inaccurate that I thought it was worth kind of bringing to you guys and really just trying to clear up some things. So with no further ado, let's kind of pull it up here. I'm gonna kind of scrub through this interview, go to a couple parts that I do want to talk about, or that he kind of said that I did want to kind of bring up and go from there. So let's kind of hit the first point. Let me make sure this is on one speed so it's not too fast for you. And let's go from there. Let's go.
The questions, you were saying something.
My first question was about the Paid in Full.
What about it?
Did you own Paid in Full? Like, how did 50 Cent acquire ownership of Paid in Full?
Let me ask you a question. Let's put this in.
That's not how this works, Dan.
I'm sorry.
This probably not a good,
you just cut me off.
What's the name?
Right? Now I want you to notice every time you do that.
Okay.
And they would say I'm bugging if I yell, but please let me complete my sentence. And please don't tell me how we do things. That's going to be a trigger. So I'm just talking normally. Do you remember when 50 Cent was supposed to be putting out a documentary about Puff on Netflix?
Yes.
Where is it?
I think it's still happening.
Yeah, right. He's capping. So I'm,
does that
you know,
have to
I
do
talk
with
a
the
different language than
paying it
most
forward?
people. I'm a boss. So number one, there is no rights to be bought. So I knew he was trolling. And you got to remember, Cam tried to have my son come on. Well, let me ask you this. Do you think?
So he starts talking about something there after that, but this is one of the things that I do want to clear up. And he maybe tried to kind of get around it by saying something in a slick way in terms of there is no rights to be bought. But I think it's very, for those of you who don't know, 50 Cent claimed, I think over the last week or so, that he bought the rights to Paid in Full, the Hood Classic with Rico, Money Mitch, so forth. And that he's kind of coming up with a TV series based off that movie that Cam is also helping them executive produce. And that's, again, one of the great things about intellectual property, specifically copyrights, is it gives you the right to have these derivative works. So if you have a TV show, you can make that TV show into a stage play. You can make that TV show into a TV series. You have the rights to do that. Nobody else can't do that. So that's one of the benefits of having a copyright. And it seems like 50 Cent, at least according to him, he has bought the rights to Paid in Full, the copyright. And what Dame Dash is saying in this video clip, which is patently false, is there are no rights in Paid in Full. Now, he did say there are no rights to be bought. So maybe he's saying, hey, there's no rights. Somebody already owns the rights and they're not selling them. But I guess number one, what he did not say is you got to listen to what they're not saying much as what they are saying. He didn't say that he owned the rights, nor did he say that, he said that he didn't say that he owned the rights. He kind of said that there are no rights to be bought. You better believe me, Paid in Full is protected by way of a copyright, and somebody owns those rights. Those are rights, and the rights are by way of a copyright. Now, whether or not those rights are for sale, maybe that's true. I'm not sure who owns it. 50 Cent apparently thinks he owns it now, but Dame Dash definitely doesn't own it, just even by what he didn't say in that case. But I just think that's a false statement. I think him saying that there are no rights to be bought, he was trying to say, hey, you can't own Paid in Full because it was a real life story. And that's just not true, man. You can take somebody, you see it all the time, these movies based on a true story. Even I think the BMF, those were kind of really based on Big Meech and kind of his crew, story back in the day, but somebody still owns the rights to those to put them in a film to dramatize them and all that stuff. Somebody still owns the rights to them, the copyrights to them. So 50 Cent, before he did the BMF series, he had to get authorization or approval or kind of, get the rights from BMF and his crew to be able to do that. So again, I do think that kind of Damon's bugging on this one, and that's kind of it, man. It's dangerous to say, hey, there's no rights to it, because it makes you think that, okay, if you have a true story that you put out, then I can do it, even if somebody else decides to do it or have the rights to it. That's just not true, man. You're going to get sued by the studios, because you got to think it's a lot of kind of protections within those copyrights: the name of the characters, the storylines of the characters, the storyline of the overall film. So all that stuff is protected, and those are the rights by way of a copyright that you obtain when you kind of do a film like that or a TV series like that. So what Dame is talking about as relates to his no rights, man, it's false, and like I said, it's dangerous, because somebody listening to that to think that they can kind of do something that they can't and find themselves in a very unfortunate situation. Let's kind of go to another part that I thought it was interesting that he said, or that he talked about. Let's see here.
Now, you know what I mean? So I did it and I timed it where it would come out when this comes out. So tomorrow there'll be an announcement. Also, I'm putting, because I've already made my Paid in Full. I made that already. It's already trademarked. You don't have to clear the rights because we lived it. You know what I'm saying? So that movie's going to come out. That TV show is I'm going to start with the docuseries. You want to see the trailer? Of course.
See, that's what I'm saying, man. That's dangerous stuff, man. That's dangerous stuff. Number one, we got to kind of break this down. Number one, he's saying that I don't have to get the rights because we lived it. And you better believe, man, if you have a TV show or a movie coming out that has the same names of the characters and the same storylines of something that's already out there that's protected by a copyright, I don't really care if you lived it or not. You're going to get sued by that studio. So if Dame Dash comes out with a movie called Paid in Full that has the Rico, that has a Money Mitch, that has a similar storylines as in the film, he's going to get sued despite what he's talking about, number one. Then number two, you have to kind of catch what he was talking about. And I kind of broke this down on another video that I did. He actually filed for a trademark. A trademark is different from a copyright. A copyright is a creative work. You think of a book, you think of a TV show, you think of a movie, you think of music, and so forth and so on. Stage play, those are creative works that's protected by way of a copyright. A trademark is a brand name. Think of the McDonald's, think of the Starbucks, think of the Chick-fil-A's. That's a brand name. Think of the Nikes. So he's saying, hey, I already trademarked it. Again, we're not talking about trademarks. We're talking about copyrights. And you don't own a copyright. When 50 saying he owns the rights to pay them for, he's saying he owns the copyright to it. And what Dame Dash actually did, I don't want to say he's probably not going to get it. It's a coin flip. He trademarked my paid in full. But again, a trademark is not a copyright. So him saying he trademarked my paid in full, he's not saying that he owns the rights to the movie. He, from a brand standpoint, to make movies, it's almost like, again, we talked about Warner Brothers and we talked about NBC Studios. Those are trademark terms. NBC and Warner Brothers, those are trademark terms. And they have it trademarked in the class for kind of film studios, entertainment services to make films, movies, TV shows, things of that sort. So what Dame Dash is saying that, hey, I'm starting essentially a production company, a movie company that's called My Paid in Full. That's what he's kind of filed for a trademark application on. And it's actually somebody who actually has the term registered for the same class for Paid in Full Empire. Now, Paid in Full Empire, My Paid in Full, whether or not the USPTO is going to award Dame his trademark for My Paid in Full in light of the registered trademark out there that's called Paid in Full Empire, I don't know. I think he has a good chance of not getting it marked, but we have to see. I wouldn't be surprised if the trademark office gave him a trademark on that, but I can see them not doing it because it's a likelihood of confusion with Paid in Full Empire. But again, putting all that to the side, because what Dame Dash is saying is he got the trademark. A trademark, number one, is different from a copyright. Then number two, he just saying that, hey, I have essentially a company trademark, a brand, a company called My Paid in Full that essentially is going to be putting out movies. That has nothing to do with the copyrights of, or the type of movies, the type of films, the type of TV shows that you put out. So if you're My Paid in Full brand studio, so to speak, puts out a Paid in Full movie that's similar to the Paid in Full that 50 Cent claims he owns, you're going to get sued for trademark. So again, I think Dame tried to dance around it and kind of threw a curveball in you with the trademark thing. And we're like, hold on, okay. So he's telling me he got the trademark, but a trademark is different from a copyright. Under the trademark, that has nothing to do with the copyright, and then really vice versa. So I did want to kind of clear that up. Then we're going to go to the last point that your boy Dame, I thought was kind of saying that was a little bit suspect. Let's kind of scrub this to hopefully you guys are kind of learning something with this. That's the whole point of this stuff. Let's go.
But this is the question though.
Can I make my other announcement?
Yes.
I have a book.
I was
deal.
talking though. You just cut me
I
off.
was talking. You just. I have a book. Deal. I want to make another announcement.
Make an announcement.
I have a book deal with Simon Schuster.
Congratulations.
Thank you. And I've already, the title of the book, I secured the rights for TV and all that. You know what the name of the book is?
What's the name of it?
Power. And I'm going to be putting a TV show on my own television network, Revolt. That's Power with no debt. And you're calling me broke because I have no debt. And you're telling me someone that gets $180 million loan is rich.
So again, you can see he's talking out of the backside, both sides of his mouth. Number one, he's saying that, hey, with the Paid in Full, there's no rights to be owned for that essentially movie. But then he's saying, hey, I secured the rights to the book Power to actually do a film. So again, you kind of see how he's kind of talking out to both sides of his what's name, where he's saying there's no rights to this film Paid in Full, but actually secured the rights, which again would be a copyright to the book to be able to, again, when you got a book, you can make a movie or a TV show off that book. And that's one of the benefits of having a copyright. So he's saying whoever, I don't know what Power book that he secured the rights to, the copyright to be able to make a film called, make a film or kind of TV shows or whatever the case may be. But like I said, that's where he's talking out the backside of both sides of his mouth. Because on one end, he's saying, hey, there's no rights to it, but with regard to Power, which we all know 50 Cent associated with the hit show Power, that kind of has, essentially a Power universe now, which really that trademark is taken by his studios. I forget what studio. I think it's Lionsgate. So he doesn't own the trademark to Power. And you better believe that if he came up with a storyline that's similar to Power for his TV show, his series, he's going to be sued. So again, it can be a number of books called Power out there, and that doesn't necessarily mean that it's the same kind of theme or storyline as 50 Cent's power, but we'll see. And to the extent that it's kind of similar, then he's probably going to get sued. Matter of fact, man, let me look up to see, is it a book called Power? Famous book called Power. Is it a famous book called Power? Famous. I should be using ChatGPT for this joint, to be honest with you. They have all the answers. I know he's not talking about the 48 Laws of Power by Robert Greene. I already know that he so again, it's a number of, let me see, man. Let me go to ChatGPT. I do want to ask this now. Does Damon Dash own rights to a book called Power? Let's see what ChatGPT says. It's thinking. So I'm gonna share my screen here. What I just typed in ChatGPT. I want you guys. We're gonna review this together. Let's see if Damon Dash is lying or not. Seems like you're still thinking. ChatGPT can take a little long. So this is what I put up. I said, does Damon Dash own rights to a book called Power? Seems like ChatGPT is thinking, it's doing a little longer than I wanted to, but we'll see. We'll see. I'm gonna give it a couple more minutes, man. If it don't kind of give me what I want to give in a couple more minutes, skip this. Just give me the answer. Okay, here we go. I couldn't find credible public documentation. Come on, what is you doing? I gotta fix this, man. I don't know why I stopped thinking. The user seems to be asking if Damon on the rights to a book called Power. It could be referring to the 50th law. The user might be referring to the way results mixed social media claims Damon Dash owning the rights. There are claims that Damon Dash do. There are trademark. Robert Greene, Damon Dash. What is about these trademarks that they're talking about? Damon Dash social media claims about the rights to power. Power. So I guess he kind of filed for a trademark application called Power Damon Dash the Memoir. A book title can't typically be trademarked unless it's part of a series, and his application could face challenges. USPTO allows intended use applications. Let's see here. Damon Dash does not own the rights to the Star Power franchise. That's clear. I already know that. Damon Dash has filed for a trademark, so it seems like he's filed for a trademark on it. But again, that's what I was saying, going back to the whole Power when he was talking about what was he talking about? Man, it's difference between a trademark as well as a copyright. So when he was talking about the what do you say, my paid in full, he filed for a trademark on that. That doesn't give him anything with regard to the copyrights, which is books, which is TV shows, which is movies, television shows, whatever the case may be. So, man, your boy, like I said, man, a lot of that stuff that he spewed it's kind of false, man. It's kind of false. So with that being said, let's go to the lawsuit of the week and get you guys up out of here. So Rotor-Rooter. Like I said at the top of the show, Rotor-Rooter, we all have seen them. It's essentially a plumbing company. And it seems like they have franchises. Really, that's if you're trying to start a company, whether it's especially restaurants, I think restaurants don't make money. However, if you can get a franchise, at least you're going to get some money to the extent that you have started it. I have a gentleman, he has some gyms, and we filed a number of trademarks for him. He had hit me up this past week saying, hey, he has like 4 or 5 gyms, but he's continuing to grow and is about to start allowing franchisees to kind of franchise the gym similar to like a Planet Fitness or LA Lifetime or even LA Fitness. That's kind of really the way to go, because now you're getting those kind of franchise fees and kind of profits or royalties of the individual locations. That's kind of really how you make money with those type of brick and mortar businesses, such as gyms and especially restaurants, man. Restaurants, unless it's like Chick-fil-A or McDonald's, they're probably going to make $60,000, $70,000 a year, maybe $100,000 a year. That's why you see a lot of the families kind of working in that joint. But if you got a franchise where they're paying the franchisor, 50 each location $50,000, $60,000 a year, then that's when you kind of killing it. Just think of Raising Cane's. I forget the owner's name, Todd, I think, but he has franchisees, different franchisees that pay him in kind of the corporate office money, and that's why they are worth like billions of dollars. So Roto-Rooter, it's a similar thing, and it seems like he had one of the franchisees go AWOL. So that's essentially what happens. There's Roto-Rooter, they allow franchisees, and it seems like one of the franchisees went AWOL, and Roto-Rooter had to sue him. You can see the R in the circle here, which lets you know that that Roto-Rooter term is protected by way of a trademark. I don't know what I'm gonna name this, so I may name it trademarks versus copyrights. Because it seems like that's the topic of discussion, at least with the whole Damon Dash thing. So let's go here, man. I gotta make these things a little smaller so you can still see me. So let's kind of go through it here really quickly. I'm not going to spend a ton of time on this, but Rotor-Rooter Corporation, which is in Iowa, I would expect Rotor-Rooter to be in Iowa, has sued Harry Chip Miller. I'm gonna call him Chip, and it's in Quincy, Illinois. So it seems like he had maybe a franchisee in Quincy. I'm actually I'll be coming back from Illinois. I mean, Chicago. When you guys see this, so you'll have some ties to Illinois here. Let's go to the background. Rotor-Rooter is the largest provider of plumbing, repair, sewer, and drain cleaning services in the U.S. And they've been around for almost 100 years, 90. Since 1935, Rotor-Rooter has offered the services throughout the U.S. under its iconic Rotor-Rooter brand. To further protect its rights, it has a number of trademarks. So you see Rotor-Rooter plumbers, the design here. You got the Rotor-Rooter pipe shield, Rotor-Rooter business advantage. They got a ton of trademarks, just Rotor-Rooter. They got them in a number of different classes: commercial and residential, water and restoration services, sewer and drain cleaning, municipalities, so forth and so on. I mean, they got a lot of Rotor-Rooter trademarks, and they have them in a lot of classes. Rotor-Rooter plumbing, drains and water cleanup. And this is how you build a brand, man. When you're talking about building a brand, you got to have a number of trademarks. That's just kind of the way it goes. It seems like they have a ton of these trademarks. Good for them. Trying to go down to the text here. So the existence of these valid and subsisting federal trademark registrations constitutes prima facie evidence of ownership and validity of the Roto-Rooter marks. Roto-Rooter has used its Roto-Rooter marks continuously and without interruption since 1935, the top of the year, matter of fact, January 1st. Furthermore, Roto-Rooter owns all rights to its logos, materials, and corporate generated content. So that's copyright. So the logos can both be a trademark and a copyright, but the materials, those copyrights, and the corporate generated content, social media content, whatever the case may be, that is copyright. So you got to be able to differentiate between what's a copyright, what's a trademark. So in January of 2017, 8 years ago, Roto-Rooter and the defendant became parties to a Roto-Rooter franchise agreement. So it seems like Chip entered into a franchise agreement with Roto-Rooter, under which Chip owned and operated a Roto-Rooter franchise in Illinois, pursuant to the franchise agreement. Under the agreement, Roto-Rooter granted Chip a limited license to use the Roto-Rooter marks and other proprietary materials in connection with Chip's franchise operation. So a lot of times when you're giving somebody a franchise, you are, allow them to have a franchise of kind of your situation, your business. You're allowing them to use the trade. You're giving them a license to use the trademarks without being sued. But again, a lot of times once that license is kind of terminated or revoked, then you no longer can use those protected terms, protected trademarks or copyrights for that matter, or trade secrets without being liable for intellectual property infringement. So let's see here. Under Section 13 of the agreement, Roto-Rooter was permitted to terminate the franchise agreement for a cause up to 60 days notice based on Chip's failure to pay amounts due to Roto-Rooter under the agreement. Like I said before, that's one of the beautiful things of having a franchise is you get a chance to collect different royalty fees or franchise fees from the individual franchisees. So on July 2023, so a couple years ago, Chip had failed to pay a past due amount of 14 racks, consisting of 6 months past due. So just think about this, man. For 6 months. So he was paying close to $30,000 Chip was to Roto-Rooter. You guys have to listen to me. You guys have to bring it back on myself. I'm telling you, man, these how you make money dealing doing these franchises. They said he was for 6 months, he owed $14,300. So just if you extrapolate that out for say 12 months for a year, he would have had to pay. And I'm not saying again, if you're making $100,000, then okay, yeah, you know, that 14,000, that's pennies. But when you extrapolate out for a year, Chip was paying Rotor-Rooter, the corporation, $30,000. Now just think of Rotor-Rooter. They said they're the largest plumbing services in the U.S. Just say they had 100 of these things. They're getting what is that what, $3 million, 300? Yeah, that's like $3 million a year just in franchise fees. See what I'm saying when I say that these franchisees can be very lucrative, at least for the franchisor. And again, I mean, the franchisees can make money too, but the franchisors are really killing the game. So let's go here. So on July 11th, Roto-Rooter issued a default termination. So they like, hey, man, we're not doing no business with you, Chip. And the default notice, Roto-Rooter provided Chip 30 days to cure all notice, so essentially to pay our money. On August, so a month later, having not received a response to cure from Chip, Roto-Rooter essentially terminated the agreement. That's what it says there. Without response or cure from Chip, the franchise terminated the agreement effective September 9th. So it gave him a chance to cure, which seemed like it was kind of a few months. He didn't cure, or didn't pay the money. So, you know, they terminated the agreement and pretty much said, hey, a lot of times they'll say either send back or trash all the intellectual property. So Roto-Rooter has issued multiple notices and requests that Chip cease and desist from using the mark. So a lot of cease and desist letters. Nevertheless, Chip has continued to advertise. So bad, hey, this bad business. That's why I had to think, what I say? Bad business. So it's one thing if Chip just went out of business. He wasn't making money. So, okay, look, y'all got me. This is no longer profitable. It makes sense to me. So I'm going to just terminate the agreement. I'm going to stop doing it. Maybe whatever the case may be. Not only did Chip not pay Roto-Rooter, not only did Chip not respond to the cease and desist letters and a notice of termination and close down services, he continued running his business under the Roto-Rooter brand. I tell you, man, which is, hey, it's a part of the game, unfortunately. It's a part of the game. So by way of example, Chip has kept the Google business profile for this business active. Got some screenshots there. Seems like he has some 3.6 stars, a couple 4-star reviews, or 18 reviews, 3.6. So he was okay. Defendant appears to maintain an active Facebook page. So he's still posting on his Facebook page. Upon information and belief, Chip continues to use in connection with his business a service vehicle that is he's still riding around in the Roto-Rooter vehicles as well. As a termination of Chip's franchise agreement, Chip failed to pay all the franchise fees in 2 years of advertising. So he's just been doing this for a minute. Chip continues to advertise and promote himself as Roto-Rooter franchisee, misrepresenting to his customers that his services are Roto-Rooter services. So let's just go through count one. Chip uses the Roto-Rooter marks in connection with the advertising and distribution offer for sale of plumbing services. Is likely to cause consumer confusion. I would probably agree with that. And Chip knowing actions and continuing to utilize the Roto-Rooter name and trademarks constitutes willful acts of infringement. I would probably agree with that as well. So these amounts are expected to be well in excess of $75,000 to be proven at trial. So that's the only one I want to go through. You guys get the point, man. So just kind of understand. Number one, that these franchise agreements these franchises can be extremely lucrative, more so for the franchisor, but the franchisee can make money as well. Number two, to the extent that you're not paying these franchise fees, you're probably going to get a notice of termination. And to the extent that you continue to ignore the notice of termination the notice of terminations and kind of run your particular store, you're probably going to get sued and you're probably going to lose. So, man, I don't know, man. It's unfortunate that people kind of do business this way, but you got good people, you got bad people, you got good businessmen, you got bad businessmen. So let me know what you guys think about that in the comment section. Like I said, I'm going to try to, as I'm going through or kind of on my way back from Illinois, I'll be kind of trying to interact with the chat and kind of let you guys know my thoughts on this thing. So, man, it was a full show today. We talked about a lot. Damon Dash in that explosive Breakfast Club interview. Talked about your boy Chip and this kind of bad business practices with the whole Roto-Rooter franchise. We talked about a Chinese AI company, Minimax. Whatever they did, they probably did, in my opinion. And Bill Belichick, seems like his first wave of trademarks have been denied by the USPTO. And go check out the interview of the week. And last but not least, man, go get the book, the ebook, I should say, Got IP, as well as go purchase the gear. Those links are in the description section. Hopefully you guys enjoyed this one. I should be back the following week live, not only live, but I'll have one of those Shark Tank kind of breakdowns or those Shark Tank reaction videos kind of coming up as well. So please hit that like button for the YouTube algorithm. Hit that subscribe button to be a part of the IP community. I'll catch you guys next time.